Hello, everyone. I'm Ian Mason, Director of Operations here at FUTO, and I'm joined by our founder, Aaron Wolf, and Michigan State University law professor and senior fellow at the Center for Renewing America, Adam Candeub. And we're here to discuss a case that has serious implications for the future of social media in this country and the law that gave rise to it. So for those who aren't aware, the Fifth Circuit issued an opinion last week, as we're recording this, that removed a stay on a Texas law that is probably the most impactful of the anti-censorship, pro-access laws that are have been passed in a number of states as we've in the last year or so. So I thought a good place to start would just be to discuss kind of the context in which those laws were passed and the history of the laws themselves. So there's no separating these things from the shift in social media policy that began whether in perhaps 2015 or 16, depending on where you look at it, where the amount of moderation and the amount of bannings, the amount of deplatforming of various kinds or de-emphasis on certain kinds of content dramatically increased. It took a while for legislatures and for advocacy groups to kind of address that. But in the last maybe 2 years, a number of attempts have been made. So Adam, do you want to maybe just walk us through a couple of those?
Sure. So there are really two efforts. One from Florida, which a social media law, which was drafted perhaps not as carefully as it could have been done, and that was struck down by the 11th Circuit Court of Appeals. The Fifth Circuit reviewed a Texas law that was really the brainchild of Senator Brian Hughes, and as well as some other people interested in it. Uh, um, uh, Professor Philip Hamburger, for instance, definitely deserves mention as a force behind this bill. And the Texas bill is much more focused and sort of narrow in approach. And what it says is, look, the content provider, the platforms can ban all sorts of content. You don't want nudity, you don't want obscenity, you don't want harassing conversations. That's fine, but they cannot engage in viewpoint discrimination, which under the First Amendment law is sort of much more narrow a type of discrimination that essentially says you can't discriminate against viewpoints. So Facebook is free to make sure you don't post naked pictures, but it can't kick off people who advocate naturism. And so this law, it was struck down by a district court. I should note that I was an expert for the state of Texas in the district court, expert witness on common carriage. And then it was upheld in a really brilliant opinion by Judge Andy Oldham. What Oldham said was, look, one, the First Amendment really isn't involved here. Most of the content moderation that platforms engage in is secret. We don't see it. So it doesn't communicate anything. And so, the First Amendment protects speech. It doesn't protect non-expressed actions, which is really what shadow banning is, prioritization, and other sort of invisible techniques which the platforms really depend upon. And then Andy Oldham said, look, also under common carrier law, the government does have a tremendous amount of regulation to ensure open access to certain essential forum. And here, the Texas law was carefully drafted, so it only affected platforms above 50 million people. And and Judge Oldham said, look, this is like a telephone company. This is like a telegraph company. This is to some degree like the cable systems, in which some degree of government regulation is acceptable in the First Amendment. So that's where we are now. Right now this is a split, amongst conservatives, among Republicans, in that the very libertarian pro-tech Republicans are against those who are, and also, interestingly enough, on the left liberal side, um, they generally are fine with regulation of speech, but don't like this regulation, and they are generally very hostile toward the First Amendment rights of corporations, as in Citizens United. But now, they're very defensive and very protective of the First Amendment rights of big tech. So it's like a sort of ideological scrambled egg. So is that good, or did I talk? Generally, law professors talk too much, so
No,
I think
it's fine. It's fine. I think a good thing would be to just provide a little framing for how that is. So this lawsuit, this set of litigation that we came up to the Fifth Circuit, got there because the platforms, that is Twitter, Facebook, the rest of the large social media platforms, through a trade group, tried to get this law, to just stop this law from taking effect. And that's how we went there. And I mean, you were saying Judge Oldham's opinion, and when I read this last week, it did strike me just in how sweeping it is in its rejection of their. I mean, I'll read from here. The implications of the platform's argument are staggering. On the platform's view, email providers, mobile phone companies, and banks could cancel the accounts of anyone who sends an email, makes a phone call, or spends money in support of a disfavored political party, candidate, or business. And then later, today we reject the idea that corporations have a freewheeling First Amendment right to censor what people say. Now, and this is a good lead into what you were talking about just before there about common carriage, because I think some people are going to read this immediately and say, okay, this is a government imposition, and that's certainly a large part of the of the tech companies' arguments are that by imposing a viewpoint neutrality standard on these platforms, you are in fact forcing them to speak. I mean, that is in essence their argument, and the Fifth Circuit here pretty roundly rejected that. Although this is far from over, and we'll get to that, the almost inevitable appeal to the Supreme Court. But I want to focus on what you were saying about common carriage, because it does take these platforms away from the sort of more general understanding of speech, even by a company as we understand it. So maybe we can start all the way from ye olde England common carriage and try and bring it up to the modern day.
Yeah, and maybe try to explain it for our audience is going to be they're not going to be lawyers, right? They're going to be people who don't want to know, how does this law affect them?
Exactly. So yeah. So there's this old law that goes back to farriers, to people who put horseshoes on horses, or innkeepers. And the idea was that they had to serve everybody. They couldn't say, "Oh, we don't like you. We don't like you." The idea is you have an obligation to serve all. And of course, the reason was obvious, is that in the 16th and 17th century, there just weren't that many farriers around, and if you wanted to go on a horseback ride and you lost a shoe, you were in real trouble. So the idea was there's certain things that are just essential for human life, for being fully participant in society, so that everybody can participate. And this idea was taken over by telegraphs and telephones in the 19th and early 20th century. And to some degree, banks. I mean, I think that also it's their insurance companies, for instance, were held to be common carriers. And it's just the idea that, look, society is being a full member of society requires access to certain basic services. And that's really the idea that's behind the law, is that some sort of basic services cannot discriminate.
You mentioned telegraphs there for a second, so that sort of is the link between, like I say, ye olde England common carriage, these inns and farriers and things, and the modern system where we have a huge number of even very high tech conveyances that are held to be common carriers and are subject to that requirement to serve all comers with some exceptions, but for the most part. So I thought one of the more interesting parts of the opinion where they did go into the history, the precedent there with telegraphs, that there really were, in fact, the prevailing view of telegraphs in the late 19th century was that, well, they're private property, their owners can do what they want with them, and that Western Union and other telegraph companies did, in fact, use that to sway political elections, to curtail union activity, to do other things. And it was in response to that legislatures, initially state legislatures, found it necessary to hold them to be common carriers in the same way that these older industries, ferries and mail carriers and these sorts of things had been in the past.
Oh, that's exactly right. And in a way, it's sort of a parallel. I mean, the Gilded Age and the Silicon Age, where you have incredibly rich concentrations of wealth in network industries on the coasts, but instead of railroads, we have big tech, and they form some sort of similar function of strangling out all competitors, and extracting rents and from virtually everyone. And in the 19th century, this was a response, and I think in the 21st century, it also can be a response. But again, it's very similar, which is, look, it wasn't just little guys, it wasn't just like, oh, give the poor rancher out in the middle of nowhere, more favorable rates. It was that, the innovation necessary to, tame the continent, to have this incredible expansion, wouldn't be possible if you had, a very nasty monopolist hanging over the entire continent, squeezing out everything like a dish rag. So I think the parallels are really there. I think Judge Oldham got it. And one last thing, I mean, I guess it's the First Amendment issue. And I think it does represent a shift in the way we think about the First Amendment. I mean, what the platforms end up arguing is that they have an expressive right to exclude people, that somehow they're making a statement when they kick people off. I don't know if that's true or not. But Oldham was the ramifications of that are very disturbing, because what it says is like, oh, lunch counters have an expressive right to, kick off people of different races or religions if they like, because they want to, express their, affiliation with a certain group.
And I think it's important to note that in that particular context, First Amendment challenges to civil rights era anti-discrimination laws, that courts have roundly rejected that rationale.
Right, they have. And so I'm confident that that they will reject them on the tech. The Supreme Court will reject those sort of arguments in the Texas social media law. But and it's a funny kind of expression. It's a sort of does anyone really look to a social media company and say, oh, I'm here so that I can. Zuckerman, hold on, what's his name?
Zuckerberg.
Yeah, so whatever. Nobody says, oh, I'm going to post this and see how he'll edit it, and I'll be able to understand his expressions and his viewpoints. It's like, no, you get on those things to exchange pictures of your kids and, see the neighbor's kid who, won the state, swim tournament. It's the idea that these entities are inherently expressive, I think is, an expansion of the First Amendment that will essentially, cut into little pieces all society. They'll have banks for conservatives and banks for liberals, and restaurants for conservatives and restaurants for liberals. And is that a country? I don't think that's a country.
So a lot of it does, if I'm not mistaken, hinge on that the extent to which it would be seen as the company speaking itself. And that's an argument they made, that this is, in fact, forcing us to speak. And there is precedent there. There's the Miami Herald case from the 1970s. For those that don't know, there was a right of reply, a state law that said that if you published an op-ed against a political candidate, you had to give them a right to respond to it. And that was held to be a violation of the First Amendment, because the editorial control that the newspaper had over some of their pages being devoted to that content would strongly imply that they, in fact, were the ones speaking by the act of publishing that. The contrasting case, I think people bring up, I think a lot in these circles, is the Pruneyard case that I think we can touch on just briefly. There's a law in California that effectively protected people making speech at a mall that was privately owned but open to the public. The mall tried to ban people speaking there, people doing demonstrations at their mall, and Supreme Court winds up holding up that law. And it's sort of before this whole set of social media stuff, I would say that's probably the furthest that we had gone in terms of what we'll call privately owned public squares.
Well, there is the Turner cases, which involve must carry on cable systems, so yeah, you're right. And I guess I think the proper response to that is that one with Miami Herald v. Tornillo, there was an op-ed page, and people who wanted to figure out what the editors of the Miami Herald had their opinions was that they could actually read the op-eds, and they would know that those that were included, the editors believed were either important or worthwhile, or they agreed, or somehow had their imprimatur on it. You cannot read all of the content moderation decisions of a big platform. They're hidden. So what viewpoint does it express? It only expresses a viewpoint in the context of other words, namely their policies that they keep on their web pages. And the Supreme Court's been clear in the case Rumsfeld v. Fair, that's saying, look, the First Amendment protects expression, but it expresses expression, and the expression itself has to communicate something, not in reference to other words. So in Rumsfeld, it dealt with a law that the Solomon Amendment that prohibited law schools and other universities from kicking off military recruiters. And the law schools, very similarly to the platforms, went to court and said, hey, look, we have an expressive right not to include military recruiters. And the court said, no, you don't. You're not expressing anything. Nobody can look at your campus and sort of see, oh, there are no recruiters here. Where are the recruiters? They're meeting over there, not over there. It wasn't a real message. So I think that's the same thing with the content moderation. There isn't a real message because you can't go to one place and say, aha, this is what the content moderation means. You have to go someplace else to their policies. And of course, the platforms are free. I mean, there's infinite bandwidth. They are free to express all the views they want. They can, in their comments, they can say, this is a bad opinion. We think this is evil. Don't read this person's post. That's fine. That's their points of view. But the idea is they shouldn't be able to block other people, and that nobody considers their users' opinions to be their own. I mean, that's just crazy. So.
I think this is a key difference. Maybe I'm mistaken, but I believe it's a key difference between the Texas and Florida laws is its reliance on common carriage and its reliance on the sort of Pruneyard-Turner public square precedent. So with that, that's at least gotten it upheld at the appellate court level, and we'll see if it gets it all the way. But I think we should discuss what they've done with that hook with the common carrier. They're saying, okay, we've decided that these are for the purposes of speech in the 2020s. Texas has decided that we're going to impose a viewpoint neutral standard. So I think we should discuss a bit what that means. How is social media different when regulations like these are in place?
Well, it's funny. I mean, I guess in a way that's going to be a bit of a tech question, and a very curious question to see what happens. Of course, right now, the tech platforms are, doing their Texas broke the internet. Judge Andy Oldham is going to, destroy us all. I expect it will simply have to be a slight, moderation of their content moderation of their moderation policy, a change in the moderation policy. They won't be able to go after people for expressing dissident views, whether that's about COVID, whether that's about transsexuals, whether that's about the Ukraine. But they'll still be able to, ban nudity, ban fighting words, ban harassing or otherwise difficult posters who screw things up and say offensive or very disturbing things. I think that they'll have to write their policies a little bit more clearly and say, look, you can't multiply post, you can't use things in a sort of a harassing way. You can't maybe even use certain kinds of words. But they can't. They won't be able to say, oh, we Twitter believe that the opinion that individuals who psychologically identify as the opposite sex are indeed that opposite sex. We can't say anyone who disagrees with that should be banned from the platform.
So let me just focus on that distinction there. Discrimination based on viewpoint and time, place, and manner regulation, and that's sort of the dichotomy.
Or even content based.
Even content based.
The whole areas of content. So.
But in imposing this standard, it's my understanding that they're prohibited only for banning or de-emphasizing or de-boosting, or there's a whole slew of verbs that the law uses, but you're not allowed to do so based on the view of the speaker. It's not a matter of not being able to have any rules. It's not a matter of there not being any moderation. It's that you cannot treat similar speech, facially similar speech that is different because of the view expressed differently. If you are, and to go through the requirements here, a social media platform that has more than 50 million users, I think that's a sort of a key distinction. This is not, saying that you can't ban people from your Discord for being annoying or just having the wrong opinion. You still can, even in Texas. But this is platforms that are over 50 million people that are open to the public, that hold themselves out as generally available to all comers. Is there any other kind of distinction there?
Yeah, no, I think that's it. I mean, they hold themselves out as serving all users, which of course the platforms do. And I think in the end, we all know what this law will do, and it's not that much, in that I think that the platforms will be prevented from putting their thumb on the scales on really hot button issues. And I think in the end, that's what we'll get if, God willing, the Supreme Court upholds this, as I think they will. And I'm from a public policy perspective, I just don't see how you can really disagree with that. For better or for worse, these few firms have cemented themselves in the pivotal places in our public discourse, and that's not what they should be doing.
So can I just ask as a normie, I kind of want to understand the mechanics here a little bit. So I say on Twitter, I love the Wachowski brothers movies. I love Matrix. I love Speed Racer. I love the Wachowski brothers. And then I get banned from Twitter and they're going to say, you're harassing the Wachowski sisters, right? Because they identify as female now. Is that what does that look like? I'm banned from Twitter now. What do I do now? I've been banned from Twitter. I feel like it's I feel like my viewpoint that they are brothers has been censored unlawfully. So what do I do?
Then you call a good lawyer and you say, hey, Ian, help me out, and you can sue to get back on. And there are no damages here, so it's not like a ka-ching moment for lawyers. Damn, but it just says you have to let me back on, and so you get into court, and they'd say, well, why did you ban them? And they say, well, we have a policy against misgendering. And I was like, well, what does that mean? It means, well, those people who have an opinion about.
Okay. And then
it doesn't strike me as so cut and dried, and I do want to make that point. Is this is not to say the challenge that's before the Fifth Circuit and presumably will be headed to the Supreme Court is a facial challenge. It's the idea that this law by its very existence is unconstitutional, not that any particular application of it So if you were to get, I am sure that the very question you are asking, should this law be in effect and in general used to the point that people were bringing lawsuits under it, this question would wind up being litigated. And my understanding of the question before a court at that point would be, were you banned for conduct or were you banned for
right? And it would be
for your view, and I would not presume to know that answer conclusively at this juncture. I mean, I have my own opinion, but
right. So it's going to become a subjective decision. Like I like Wachowski brothers movies is not as bad as saying, you know, though they're actually like, man, why are they like, you know, at some point you get to actually targeted harassment, right? And there's going to be a continuum, and a judge decides this, or juries decide this, or.
I think a judge will decide it. I think that they'll probably, you know, emerge rules that people will. I mean, I think repeated postings, for instance, I think, you know, objective indicia of harassment. So, for instance, there are ancient laws about, not ancient, but like, no, from our perspective, about 80 years old. No, hold on, 60 or 70 years old, about telephone harassment. And telephone harassment is when you make repeated phone calls, or you make, you call up and say, you know, is your refrigerator running? And well, you say yes, and you could better go get it. And those sort of, you know, facially and obviously harassing comments, harassing behaviors, would be, you know, bannable. Now, your question, there will be some line drawing. But I think my hope and my expectation is that, you know, perhaps you know, rules and standards would be developed so that people could express their viewpoints in the same, but, you know, once they cross the line into sort of behavior that was menacing or harassing, then the platforms could say no. And as I was saying, their content moderation would shift from the content of what was said to the manner and how it was said, and to the manner in which it was said. And instead of looking at, you know, we disagree with this, into, well, was that said in a way that was, you know, impolite, that violated our rules, that you know, was menacing or harassing or not, you know, constructive of conversation. And I think that the platforms actually could make that determination somewhat objectively, but, you know, if they had the threat that if they, you know, veered off into their, you know, ideological you know, preferences, that, you know, the court could come and say no.
I think we have a tendency to focus on the hard cases for obvious reasons. It's more interesting, but that isn't to say that should this law be upheld and go into effect, there won't be easy cases. If you take common carriage laws with telephones, I think it's very, you bring up telephone harassment there. Yes, there are hard cases as to whether you calling all your neighbors in support of some cause repeatedly, you know, might veer into harassment. Or
at least when I was in high school, when calling girls up on dates, they all thought it was harassment.
Well, yes, I mean, there is a point at which that, you know, that could be made, and them turning your telephone line off might wind up being upheld. But there are easy cases too. You know, if it's if they're turning your telephone service off because you're a union member, it's going to run afoul. It's an easy case, and I think that in this new common carriage context, you're going to wind up with easy cases too. Political parties treated differently for identical content. People expressing view X and being promoted. People expressing view Y and being de-emphasized in results or even banned. As I see it, people want to avoid those easy cases, so they're just not going to do as much in that regard.
Yeah, I think that's right. I mean, I think the you know, the real sort of blatant the blatant sort of excesses that we've seen, you know, the Hunter Biden tapes, the COVID, you know, disinformation campaign, really things that I think have had a very detrimental effect upon public discourse. I think that the platforms will know that they can't do that, because, you know, there will be, you know, some metal fist, mailed fist in the velvet glove to say no. But I think we could end up with a series of court rulings that are relatively generous and human toward the platform, saying, look, they have to maintain standards of communication so that people will continue to go on them and make their comments and be exposed to the ads, or else the world will collapse. And I think there's a room for the development of those rules, and I think they could work. And yeah. So.
You brought up the COVID disinformation stuff that has been a big issue in content moderation or censorship in the last few years. It's most interesting to me because it's sort of where government and these platforms have most closely interacted. And I bring this up sort of to address, because there's a strong tradition of thought that, there's public and there's private, and what's private's private, and the government shouldn't be involved in any sort of speech related decision. You can't call the government in as a referee, and on a philosophical level, I'm personally very sympathetic to those kinds of arguments. I also happen to think that they're misplaced in these areas, in large part because these large platforms are so closely intertwined with government. And I know that this is cited in the opinion and a few other places, some of the amicus briefs. But in the COVID context, there were numerous instances that have been now publicized of government officials in close contact with the censors of these platforms, saying what content is to be removed, doing in effect recommending actions that if the government were to take them themselves would be blatantly unconstitutional.
Yeah, well, so I've written about this. Actually, Philip Hamburger and I have a post on this on the Bala conspiracy. Now, part of the reason we have common carrier laws is simply to avoid that strategic problem. So, if you look at Europe, for instance, government had a much bigger role in telephone and telegraph rollout. Surprise! And they dealt a lot more. They had a lot more control over who got connected than in America. And part of the reason was common carrier laws, because when the government came, knocking to, AT&T, and, after 9/11, they do give in to pressure. That's true. But generally they would say, look, I would love to help you out, oh powerful government official, because, no doubt we can make, useful trades of something further on, but we can't, because it's common carrier law, and there'll be some annoying lawyer somewhere who will sue me, and everything will come out. We can't do that. And so I think common carrier law often played as a role throughout the history of network industries of a way of fighting government intervention, which of course they will. When you have concentrated network industries, it's cheap for the government to put its finger there and at the nexus of it all and exert a lot of power. So that is one. I think these laws are very much a response to that threat, which is real. I mean, the documents that have come out showing the coordination between big tech and the White House and HHS, it's very distressing. And the common carrier laws, one would say no, because the collusion, of course, can still happen in some way, but the common carrier laws adds another cost to the network and says, look, yeah, you can make your little deal with your political friend, but there may be a bigger cost down the road.
And even before that sort of latest intertwining of private and public efforts to, let's say, curtail certain kinds of speech, it isn't as though this separation were so perfect. They're a bit. I feel like maybe too much has been made of it, but I feel like we should briefly discuss Section 230, and it's here. This was a real sort of a big talking point. I want to say maybe 3 years ago, but there is a good core to it. I feel like some people have misunderstood it and taken it too far. But for those who don't know, Section 230 of the Communications Decency Act was passed in the 90s. Among other things, it excludes largely the things that would become the same kinds of platforms, and many others, most websites, in fact, from virtually all kinds of liability for content that their users post. In effect, saying that they are not under any circumstances publishers of that content for purposes of liability. Much of the argument against laws like this hinges on the fact that they are in fact publishers, because they edit.
Yeah, so this was an argument that was made in several of the amicus briefs, and for people in the sort of anti-big tech biz, it's so the Section 230 positioning of which big tech has done is one of the most irritating things in the world, but they're really good lawyers and they can do what they want most of the time. So that's right. So under Section 230, Facebook does not have liability for the content that its users post. So if I were to post, some libelous thing about, Ian, beats small puppy dogs, clearly false, certainly libelous, and given how much Aaron loves dogs, probably hurtful to your career, so you could sue me, and under traditional common law you could also sue Facebook. But Section 230 comes in and says, no. Facebook is like the telephone company. It just transmits messages. The messages it carries are not its own, so therefore it has no liability. And that's what Section 230C1 says. Section 230C2 is sort of a gift to the anti-pornography crowd, because it essentially says, look, if Facebook decides to edit all their posts to get rid of very specific things, all relating to mostly sex, then they don't become the author of those materials. Those materials still remain are still the publications of the users. So Section 230 says, platforms are not the publishers are authors or speakers of their users' post, and even if the platforms get involved with the posts just to remove the sex stuff, mostly harassing material as well, they still don't become publishers or speakers of the material, and they still have no liability. And that is the argument the platforms have made in hundreds and hundreds of cases. They said, look, this is not our speech. It's the user's speech. We have nothing to do with it. No liability. Now, however, they're saying, when we carry people's speech, when we transmit it, it's our First Amendment protected right to do so. And if you tell us and make rules about how we can carry speech and say we can't discriminate against this speech and can't discriminate against that speech, well, that's our speech. Even though one of the Section 230 cases, they said, oh, no, that's our user's speech. So it's that sort of, having their cake and eating it too, that Judge Oldham really couldn't really deal with. And he said that was nonsense. Either you're in the business of transmitting speech and it's not your speech, or you're in the business of publishing speech and it's your speech for First Amendment and for liability reasons. So that's sort of what Oldham said. And, that was one of those gratifying parts of the opinion, because as someone who's been involved in Section 230 litigation, we constantly say this. And, we haven't been, we haven't had too many receptive audiences, with the exception of, perhaps Justice Thomas and a few dissents in the circuit court. So this was very nice to hear, and I'm glad you got it.
You bring that up. I think the opinion was incredibly comprehensive, sweeping in how many of these different things that have come up over the years it agreed with. It really was exciting for me to read. We'll put the opinion link in the description there. I recommend it to anybody who's interested in these issues. But as that, it was sort of a catalog of these different issues that convinced me years ago that something like this law was a positive thing. We're based here in Texas, and it's interesting, to be here just as my adopted state is kind of at the frontier of this kind of a law. Things like the platform's appearance as a public square, as a kind of thing that is regulated as a common carrier in other contexts, the hypocrisy on regulations like 230 that they liked, their willingness to get in bed with the government in order to put the thumb on the scale in political things, convinced me that something had to be done in terms of stuff, in terms of government action at state or federal level. So I want to maybe shift the discussion to that sort of meta discussion about the state of social media and what can be done. I know, as a gut reaction, Aaron, I think you're loath to lend your support to any kind of sweeping set of regulations, and are usually much more focused on the technology side. But I know
Right.
that the circumstances here kind of convinced you that this was a...
Yeah, definitely. So, I mean, FUTO supports this bill. But let's talk about the history of this. As a programmer in Silicon Valley for 18 years, I mean, we would always look to the EFF in these kind of cases to give us guidance. Just because, we're programmers, we don't want to be digging into these laws, and, one little sentence in the law can flip it from being, pro-innovation to anti-innovation, or pro-government to anti-government, right? So, as a programmer, I am very, very anxious about any law that tells me what I can't program. I want to be able to program whatever communications platform I can imagine. I noticed with this, the EFF is actually against this law. So I was like, oh my God, what's going on here? I need to dive deep into this. And it really is, you kind of look at, EF has posted many articles about this, and, they never mention the 50 million active users requirement. So the law does not even apply to you if you're just trying to disrupt the monopolists. If you're trying to write a new communications platform that disrupts what Twitter's doing or what YouTube's doing, or what Facebook's doing, you're free to do that. This law will kick in once you get to 50 million active users, which is, you're a success at that point. And honestly, my recommendation would be for anybody programming these things is that you should not be programming these in a way that the developer of the tech is also responsible for moderating how it's used. So I'm kind of, and it honestly kind of bothers me that, the EFF is writing all these things about this bill, and they very rarely mention that 50 million, active user requirement.
Or the fact that the law has, no damages. A bill, the worst that could happen is you have to give people their account back.
And I mean, I certainly, if it didn't have the 50 million requirement, would not be for this bill. The justification is that sometimes you have certain kinds of private firms that perform public functions to some degree, and that this is a very mild type of regulation. It says, you just may have to have more users. It's like that they should like that. And it's worked before. I mean, telephone companies, airline companies this day, FedEx, and it seems to me that it's carefully focused enough on viewpoint. And as he says, Aaron, it's really a very distinct and type of company, huge ones, that even libertarians should at least consider the possibility, because it's freedom enhancing. We have to admit that. I mean, it is.
I mean, generally, we're going to be, the biggest problem is we have monopolists making too many decisions. The government should get involved when it's weakening the incumbent advantage or, the power like of the monopolists. And this sounds like this is that kind of case with this HB 20. There are other situations like, I get really like the stupid EU law that like puts that cookie warning on every website. It's just stupid. Like, we definitely don't want laws that are going to be, propping up bureaucracies in Washington D.C. to kind of tell us how we build tech. Like, we want programmers to be able to solve these problems. We want individual programmers to be able to solve these problems, and this will help that. This weakens the big giants who are kind of squashing competition, and it helps the little guy.
Right. I mean, and creating what we really want, a community of vibrant, active businesses that are smart and working together and antagonistically, not being coordinated from some great central place.
I don't. This is maybe not the right thing, but let's maybe address the slippery slope arguments, the horror show, the parade of horribles, that not just the platforms, but I think some very well-meaning people with whom we agree with most things on technological issues or legal issues, look at a law like this and see a slippery slope to government regulation of speech, or at the very least a patchwork of state laws that make technology very unworkable for large organizations. I don't have great fears of either of those things from this bill. I mean, there are obviously things can go 100 different directions, but I think we maybe should address what's your horror show version of events as to how this goes wrong for speech and for tech freedom.
Yeah, well, two issues. One is the patchwork issue. I mean, California's already done it, and it's so interesting. Consistency is the hobgoblin of small minds. So I don't want to ascribe to the people on the other side to be great geniuses, but they're generally silent when it comes with the patchwork problem when it comes to the California network neutrality rules and the California privacy rules, which getting back to your EU point about the stupid cookie tags, are quite burdensome, and they're an export of California views. Companies, for better or worse, have a way of dealing with this. I mean, I think what is really bad for patchwork issues are is that they affect the small guy the worst, because they have the least resources to deal with these huge numbers of regulations. And so yes, I mean, I think that patchwork issues are a real problem for the small guys. I mean, you see, I mean, I do a little. I some continue and do some sort of representation of clients, and the small websites I represent, the California thing has been a bit of a pain in the ass. But that's the whole thing about HB 20. It's like for Twitter, and Twitter and Facebook. I mean, they're not going to have any problems with dealing with this. So I'm not that sympathetic when it comes to the patchwork argument, because they have so many lawyers and they certainly have the resources to deal with this sort of law. I think the parade of horrors that you hear most is that people's feeds will be full of Nazi propaganda and I don't know, solicitations to join ISIS or things like that. On one hand, I'm not sure that's the case. I mean, you get to block people. And the other thing is that, something that Elon Musk said when he was considering taking over Twitter is that, wouldn't it be great if we could open source content moderation programming so that people could decide what they wanted to view? And they could have control over what they see. If HB 20 pushes the platforms in that direction, that's a good thing, not a bad thing. They claim they're such great innovators. Well, okay, this is a problem. You can innovate around it. So.
And there's law has the whole set of transparency things that I think encourage that as well. This has gone on. We're at about the hour mark now. I think it's probably a little late to get into the transparency provisions of the laws, but suffice to say that I think that they are the more transparency we do have into content moderation, the more informed decisions consumers can make, and so on. So I think that that's also a good thing. Adam, thank you so much for joining us here. We're really looking forward. I understand that this is, I don't think an appeal has been filed yet, but I would be surprised if this is not on the Supreme Court docket this term, October term.
We'll see. I mean, I'm sure there are, incredible, conference rooms full of incredibly very highly paid lawyers who are, carefully plotting out the next steps for big tech. Whether it's going to be they're probably going to almost certainly move to stay the mandate. So to make sure that the Court of Appeals opinion doesn't go into effect. And then the question will be whether they'll appeal to the entire Fifth Circuit or whether they'll take cert in directly to the Supreme Court. It's notable that Florida has just applied for cert for its social media law to the Supreme Court. So things are moving.
Well, thank you so much for joining us today, Adam. It's been a really good conversation. This is, I think, a really important development in the social media space, and we're gonna keep monitoring it.
Well, it's great. I'm very grateful for your interest, and keep on doing the things that FUTO is doing, which give me hope that technology may actually help us one of these days. So I'm looking forward to that.
Thanks.
Take care. Thanks so much.
Bye.